Trains too large for the tracks, sabotage of infrastructure and business having to resort to using the more expensive option of the roads to transport goods, leading to accidents and deaths. These are just some of the issues facing Transnet, and some blame a history of corruption. Well, the Transnet fraud and corruption case involving about 400 million rand has been postponed until April ahead of being transferred to the High Court for trial. Now, those facing charges include two former CEOs of Transnet, Molefe and Siyabonga Gama, as well as former CFOs Anoj, Singh and Garry, Pita. They appeared alongside directors and shareholders in Regiments Capital that did work with Transnet, including Eric Wood. Now, the former executives are charged with contravening the Public Finance Management Act, while others are charged with fraud and money laundering. Let's get some legal analysis. We're joined by legal analyst Sinawo Makangela. Sinawo, thank you for being with us as always. This relates to the more than 1,000 locomotives, an infamous deal now in South Africa, and there's been a lot of claims around that, bribery claims, but this is specific to a 30 billion rand loan, or a double loan. Can you just give us the details of what is actually in court?
Okay, thanks, Francis. In fact, at this stage, what we know and what has been in the media is that in that transaction to secure those 1064 locomotives that involved 30 billion rand, there were some illegal activities that occurred there. There were some double payments, and there was some movement of cash to some foreign financial institutions. Hence, the law enforcement agencies had to follow up on those issues. So it's a very interesting one, because we all know that the public transport has been severely affected. We all know that some of the train stations are ghost centers. People are unable to move to their workplaces, of which trains were transporting thousands of South Africans on a daily basis. So it's not a light matter. It's a very serious issue that the state has to take up to.
And it should be obvious because they're using taxpayers' money here, but the Public Finance Management Act holds executives of state-owned entities to higher account because of that. Just give us some of the details.
Definitely. In fact, it is sourced from the Constitution. Relatively, what you can see, every legislation is sourced from the Constitution to ensure that the public resources are spent wisely for the benefit of the public. Now, if you talk about the PFMA, it is applicable to the national government and the provincial government, including the state-owned entities. Now, those who are called accounting officers there have got some obligations they have to perform. Some of those is to ensure that they ensure the spending of the resources is done efficiently and effectively. Once there's a waste, it means there's no efficiency, there's no effectiveness of ensuring that the public is protected there in that space. So once there is a legislation that requires one to perform, and that person fails to perform, that person has to be accountable. Actually, this is a call to all those who are occupying public officers, who are called accounting officers, that the law will hold them to a higher degree to account for the conducts, for any wrongdoings that happen during their watch, because they are accounting officers in terms of the law of their land.
And fraud goes even further. So the executives and the others are accused of fraud. There's money laundering as well. So essentially the claim here would be that the executives knowingly commissioned work that wasn't necessary, or knowingly commissioned double work, or knowingly commissioned work for a bribe, etc., etc.
But imagine, who can say, I did not know that regiment was paid, hence I had to pay a trillion? I mean, it does not exist. We know that in these institutions there are files. Whether somebody came in after the other has left, but you would know that what happened, where did it start, who has been paid, what happened. So obviously that knowingly is something that we expect the state to prove. But remember, the test in the criminal proceedings is that the state must prove its case beyond any doubt. So it's an information that we believe, because these are transactions, they can be traceable, that Transnet paid double the fees, paid the regiments and paid trillion. So at least they should be in possession of that particular information. And the Act tells us who must be accountable in these institutions. There are other officers, that's why you find the CFOs here, and some senior executives, because even them, their obligation is sourced from a statute. So it means they failed to observe what is required of them by the statute. Hence, they have to be accountable for their actions, because everyone has a task to perform. At least if somebody was forced, hypothetically, somebody was forced to undertake a particular transaction, the person must demonstrate, because he's the person who will be held accountable, as is the case now.
The National Prosecuting Authority was criticised at one stage for unsigned draft charge sheets. Those were presented in court. Whatever happens now, do you agree that this is very important for the MPA? It's very important for the MPA to show that it can prosecute high-profile cases successfully and be on top of state capture right now.
Francis, the excuses now, that time of accepting excuses from the law enforcement agencies has come and gone. This matter has long been in the pipeline. The point is here, the Constitution guarantees the rights to individuals. If you charge somebody, there is a cloud hanging over that person. Once you charge, you don't charge and then investigate. You investigate and then charge. It cannot be acceptable that the NPA at this moment is presenting flimsy excuses and explanations. Even in terms of the norms and standards in our courts, the norms and standards adopted by the judiciary that the matter must be finalized within 3 months. They anticipate that by the time the matter is brought to court, it means investigation has passed, at least even if it's 90%, so that you don't come and cause the backlogs, because you'll come back and say, there is no finalization of cases in our courts. So NPA, at least by now, you cannot be talking about the charge sheet. It's not signed, it's flimsy. You know what the Criminal Procedure Act says. It is not acceptable, because it means, what are you saying about those individuals? They need their day in court. Let the court determine this matter. It must move away from the hands of the NPA. NPA, go to court, present evidence if you've got any. Allow the court to make a determination. Let them present their own defense. Let the court decide. You can't be having a cloud hanging over somebody's head. People's rights must be respected. NPA must respect. Remember, the rights are not only the rights of the accused persons, the rights of South Africans who are suffering from the fraud that took place in those state-owned enterprises. The rights of those who can't be able now access their workplaces, who are working for the transport because trains, where the cheaper modes of transport are no longer available. Their rights have to be protected. So NPA cannot always come and plead for sympathy. They have to perform the act. Whoever is given a task within the NPA, they must do their job. Simple.
All right, final question. McKinsey, a former partner, is there. And we know, I mean, in relation to these big global consultancies, Bain, there's an investigation into whether there should be a prosecution there. There have been other big names. But is it significant that a former partner has been indicted? Can we get a sense of how big business was involved in state capture?
Well, Francis, it's telling us that billions of rands have been involved. There's no question about the value. There's no question about it. But the only thing that as South Africans can pin our hopes is that the NPA is not only playing to the gallery, at least those who have committed this malice with the public funds are held to account. At least the NPA must be seen to be doing something. Remember, how many investigations have been happening in these issues? You've got the state capture report. It has been giving us as well there are some groundbreaking findings in that report. Now, at least there is some groundwork that has been done by the commission as well. Now, what is left is for the NPA now to do its job.
Yeah.
Bring in people, prosecute. Make sure that you prosecute with speed.
All right.
The point is that they must prosecute in speed so that these matters can be finalized, so that at least as South Africans we can move forward.
All right. Thank you very much for your analysis, Sinawo Makankela, legal analyst.